2014, Indiana became what's commonly called a 1634 state, meaning that now, in order for an adult to have Medicaid, the Social Security Administration must determine that the person is disabled. There are two exceptions to that requirement. First, children are not required to apply for SSI or SSDI. And the biggest reason for that is, unlike Medicaid, when a person has a waiver, Social Security absolutely looks at family income and family assets. And as a result, most children would not qualify for SSI. The second exception are those with religious objections to accepting federal benefits, like the Amish. When it comes to applying for Social Security benefits, typically you want to apply after the individual turns 18. You can certainly apply before that time, but prior to age 18, the Social Security Administration will consider family income and family assets when determining eligibility. If an individual receives Social Security benefits as a child, they must reapply as an adult, and there are different eligibility requirements for adults than there are for children. Social Security has two different Social Security disability programs. The first one is Supplemental Security Income, or SSI. This is designed for people who are aged, blind, or disabled and have very low income and very few assets. The maximum SSI benefit in 2019 is $771 per month. The second program is Social Security Disability Insurance, or SSDI. This is typically designed for people who have been working their whole lives and become disabled. However, individuals with intellectual and developmental disabilities may also be able to qualify for SSDI if they have their own work history, but also because they're what Social Security would consider a disabled adult child, and they may be able to get SSDI benefits based off of their parents' work history when they have a parent who has retired, become disabled themselves, or have passed away. And benefit amounts for SSDI is going to be based on the individual's work history. The good news is you don't have to decide which program to apply for. The Social Security Administration will decide which program is appropriate. You may be able to start the application online at ssa.gov. It will typically take 2 to 3 hours to complete all of the paperwork, but one of the important things is you want to list all of the disabilities the individual has ever been diagnosed with. There will also be a question on there to ask if anyone has helped the individual with the application. If the individual is getting help, you want to say yes, and you want to say who is helping them and why they're getting that help. However, if you're applying for SSI, you will need to make an appointment with your local Social Security office to go in and finish the application process. And you want to provide any and all information to help show the individual's level of impairment. There are two different types of information Social Security considers when they're making their decision. The first type is medical information, and medical information is given the most weight. Now, Social Security will often try to get some medical information, but they may not get everything that they need. So it's important to make sure that you inform your doctors to expect this request, and you may want to consider gathering the documents yourself and providing them to Social Security. It's also important to know that Social Security may send the individual out for testing with a Social Security approved doctor before they make their decision if the last evaluation is not recent. It's also important to know that Social Security may send an individual out for additional testing with Social Security doctors if the individual doesn't have any recent testing or evaluation results. Before you apply for Social Security, we recommend making sure that your medical records are up to date and very thorough. So make an appointment with your doctor and get as much information in the person's medical records as possible to show their level of impairment. One of the things you may want to consider is contacting the Bureau of Developmental Disabilities and getting their level of care screening. That's the evaluation that the Bureau of Developmental Disabilities conducted to qualify the individual for a waiver, and that has a lot of valuable information in it. You can share that information with your doctor, and your doctor may want to include that in your medical records to help show the person's level of impairment. There are also residual functional capacity forms available, which directly address some of the concerns Social Security has and provides the specific type of information Social Security is looking for. When you're talking with your doctor, you want to explain how the person's disability affects their daily life and get that information into their medical records. And you want to give concrete examples. For example, if someone has migraines every week that would require several hours to recover, that's the type of information Social Security needs to understand. If they have anxiety attacks that take an hour to recover, that's the type of information Social Security is looking for. If they can't maintain attention or stay on task, those are the types of things Social Security is looking for. Social Security is looking for information that directly impacts a person's ability to work, and that's the type of information that needs to be in the person's medical records. However, Social Security will also consider non-medical information. Now, it's not given as much weight as medical information, but it can make a difference, especially at the appeals level. A person needs to provide any information or documentation that shows how their disability or how their impairment affects them. Some of the non-medical information to provide might include that level of care screening from the Bureau of Developmental Disabilities. It might include relevant incident reports or letters from providers. If they're working with vocational rehabilitation services, providing their VR file, but also looking at what types of impairment-related work expenses they may have, what types of job accommodations they may need, what types of employer subsidies they may need in order to work, which would include things like a production level. All of that is relevant to Social Security and can make a big difference. You may even want to include the individual's IEP, letters from teachers about what the individual needs help with, what type of speed and accommodations they needed compared to other non-disabled students. Depending on the situation, you may even want to consider keeping an activities of daily living diary for a month or two, just to show what types of things the individual can do and the things the individual needs help with. Also, if the individual has meltdowns or anxiety attacks or significant behaviors, one of the things to consider are those ABCD reports, the antecedent, what was going on right before the behavior happened, the behavior, what did they actually do? C is for the conclusion, how did it finally resolve itself? And D for duration, how long did the meltdown or the anxiety attack or the behavior actually last? All of that type of information can be helpful with a Social Security application. So it's also important to know who makes the decision. With the first application, it's actually the Disability Determination Bureau, which is part of FSSA, who makes the initial decision. If you're denied and you appeal, the first appeal is also determined by the Disability Determination Bureau for redetermination. It just goes to a different team. If you have to appeal a second time, that's where you go before an administrative law judge, and that can take 18 months or more to get to that level. If you have to appeal a third time, that's where you would go to federal court. And at any point along the way, you may want to consider getting an attorney to help you with this process. Some individuals don't necessarily want to appeal. They think it might be easier to reapply. However, with Social Security, in order to reapply, something needs to have changed. And if there hasn't been a change, some Social Security offices won't even take a new application. It's also important to know that it is incredibly common for people to be denied several times. So it's important to keep appealing. And it's also important to know that if you already have Medicaid and if you already have a waiver, before you get that Social Security denial, you can keep your Medicaid and keep your waiver as long as you are appealing that Social Security decision. However, it's also important to know that if Social Security ultimately decides you are not disabled, the state of Indiana can request that you pay back any money that they spent on your care. If you'd like to talk more in depth about your personal situation, you can contact one of our family advocates at 317-977-2375. But now for the disclaimer. I want to make sure you understand, I am not an attorney. This is for informational purposes only. It was designed to talk you through the process and help you determine what information may be appropriate to help Social Security in their disability determination process. I also want to point out that some of the information we gave today may be different from Social Security's official policies, rules, and procedures. Part of the reason we've done that is because we want to share information about what we see occurring in real life to help you through this process better. For more information on this and other topics, visit the ARC of Indiana at arc.gov. ind.org, and the Indiana Family and Social Services Administration at in.gov/FSSA. And please, don't hesitate to contact a family advocate at the Arc of Indiana by calling 317-977-2375 or 800-382-9100.